right, Derek, I'm going to jump in on fair housing. As you guys might know, the Fair Housing Act, as it's known, is actually just a subsection of a broader statute, the Civil Rights Act of 1968. Interestingly enough, that covers discrimination in the workplace, it covers discrimination in higher education, and of course it covers discrimination in the sale or rental of housing. So as I just mentioned, Title VIII, that is the Fair Housing Act, Title VIII of the Civil Rights Act. It covers and it makes it unlawful to discriminate against individuals in the sale or rental of housing based on a protected status. Now, Derek, what are the protected statuses that are included in the Fair Housing Act?
That's a great question. So they actually include race, color, religion, sex, familial status, national origin, and handicap.
And a couple of brief notes with familial status that actually it covers families, but a family does include a single individual. So that's really important. I think that might trip you up a little bit just because it is familial status, but right. A single individual would be covered under that. And also, just touching on handicap, we'll cover it a little bit more later, but that is more broadly covered in the Americans with Disabilities Act.
Let's talk a little bit about why consistency really does matter. Now, let's just say, hypothetically, that we have two different buyers who contact a real estate agent to inquire about a property that is listed for sale. The real estate agent requests a pre-qualification letter from the first buyer from a lender prior to showing the property, but does not request it from the second buyer. Keep in mind the agent is unaware of the national origin of either buyer. Now, why I find this question, or this scenario rather interesting, is because I think most fair housing violations, they're unintentional. The agent has absolutely no malicious intent, but it's that lack of consistency that can lead to issues later down the road. So by the time buyer A provides their pre-qualification letter, just to build on our scenario, the home is sold to buyer B. Has a fair housing violation actually occurred?
So the answer is likely yes. And Derek touched on a really important point, and we built it into our fact scenario here. The agent is unaware that they, come from different national origins. And she's probably unaware that she asked for the pre-qual on the first one and then just absentmindedly or just unintentionally did not ask for it in the second scenario. Fair housing is not looking at intentionality, as Derek touched on. They're looking at the effect and if there's an injured party. We know we have an injury here because now the buyer A had to go and get the pre-qual letter, missed out on the home. We've got an injury. Even though we don't have the intentionality, the agent is completely innocent in their mindset, there still may be a violation there. So as Derek said, consistency is so key. If we're going to ask for the pre-qual letter, we need to ask for it across the board. And then that way, we know we're treating everybody the same, which is really the call of the Fair Housing Act.
Right, and keep in mind, fair housing, they do have testers who will call, and our industry is targeted, of course, but they will call real estate agents and they will ask questions and they will then perhaps have another tester call back who maybe fit a different mold, ask similar questions just to see what if there are any inconsistencies in the way that they are treated.
Right, and this one really just points out, we know that especially solid source agents, they're not out there intentionally discriminating against folks. But in the application, based on a scenario where the agent is acting, in their minds completely innocently, we still have liability because the effect of what happened, we've got an injured party and they missed out on a potential sale.
Right. Let's talk a little bit about who enforces the Fair Housing Act. Now, of course, it is enforced by the U.S. Housing, the Department of Housing and Urban Development. Beyond that, let's talk a little bit about how this applies to real estate brokerage firms and agents.
So as we touched on, more generally, fair housing covers discrimination in the sale or rental of housing. Now, this is actually taken not verbatim from the statute, but sort of paraphrased from the statute of the specific things that are covered under here. And so the first one, it may seem obvious, but it really is to refuse to sell or rent, or to refuse to even enter into negotiations with a party to sell or lease the house based on a protected status, one of the protected statuses that we mentioned earlier.
Let's also talk a little bit about advertising. So also to advertise a dwelling in such a way that indicates a preference, a limitation, or discrimination based on any of the protected classes. And keep in mind, and I'm going to touch base a little bit on photographs, because one good rule of thumb is when it comes to advertising, if we keep the advertising, the language, and the photos to the actual real property itself and not the people or the types of people, activities of people that we think might be interested in the home, that's one way to keep us in the right lane. I think when we deviate away from the real property and start talking about activities and people, that's when we can find ourselves in trouble.
One of the other important provisions here we have, you're not refusing to negotiate or sell the property, but you're giving different terms and conditions to one party based on that protected status that you would not give to another party who doesn't fall within that class. And so that also is prohibited under fair housing. Another big one, inducing a party to sell or to rent out their property based on this notion that members of a protected class may be coming to the area or something of that nature. Definitely a no-no, definitely prohibited under fair housing. And again, these 5 categories here just go to the general proposition that any time that we're discriminating in selling or leasing housing, it's going to be a fair housing violation. And consistency, as Derek mentioned, really does matter, because I know you guys aren't out there doing it purposefully, but we just have to be really mindful of our policies and whether or not they're consistent across the board.
Absolutely. A little bit about handicap status. So it's covered more broadly in the Americans with Disabilities Act, but let's talk a little bit about what qualifies. For example, a physical or mental impairment which substantially limits one or more of a person's major life activities. Protections are broader than the other statuses because it protects the buyer or the tenant and any person associated with them.
Right. You can think of the scenario where possibly a mother with a handicapped son is looking for a property, and the mother's the only one there encountering the agents, and she's saying, I need a ranch because it's going to be more accommodable to my son. The son is not present. The son's likely not going to be on the contract. Still covered, because if the agent were to know about the son's handicap status and then makes it unavailable, that's going to be a fair housing violation.
And let's talk a little bit too about reasonable accommodations. The refusal of a reasonable modification of the property or a reasonable accommodation regarding the terms and conditions. So let's say that you have a landlord who does have a prospective tenant and who is proposing these changes. Are they allowed to deny the changes? Must they grant them?
So, and it's going to be fleshed out a little bit more on the hypotheticals that we have on our next slide, but Derek, that's a really good question, because what is reasonable in one situation may or may not be reasonable in the next. So these things are completely fact determinative, meaning each case is going to be decided on a case-by-case basis. The law does not, they leave it general purposely. They're not going to lay out situations where one thing is going to be reasonable versus another scenario where it would be unreasonable. And so the best practice probably is for a landlord or a seller to err on the side of saying that it's a reasonable modification or accommodation. You really could never go wrong there. And of course, encouraging them to seek out legal advice if it is sort of a gray area.
Is a reduction or waiver of a pet deposit for a service animal lawful? Let's look at a hypothetical here, if you will. So Jane is working with a landlord to find a tenant for 123 Main Street. John, who is handicapped and requires a service animal, applies to rent the property. John inquires whether a pet deposit will be required, as his dog is a service animal. Jane says yes, but they may be able to reduce or waive contingent upon how well behaved the animal is. Big question here, has a violation occurred?
So the answer there is, again, yes. And the reason for that is the whole problem with this fact scenario is that it's being referred to as a pet to begin with.
Right.
So a service animal is not considered a pet under the law, under Georgia law, and under federal law. And so if we're talking about, oh, okay, I know it's a service animal, so we'll give you a reduction in the pet deposit, or we're going to waive this altogether. I'll add that exhibit, but we're just going to cross through it and say waived. that's problematic because you can't reduce or waive something you never really had the right to charge to begin with. And I know that can be tricky. You're thinking, well, it's a dog, and we generally think of them as pets, but get in the mindset of qualified service animal, not a pet. Pet deposit doesn't even come into play. We're not reducing them, we're not waiving them. And again, if the landlord has questions or they're pushing back a little bit, you can refer them to the statute, and of course, they should seek legal advice if they're a little bit confused on their obligations.
Absolutely. And it might be a good thing to discuss up front, just in the efforts of being proactive, with a seller or a landlord, really is when it's going to come up, with a landlord when they go to list their property for lease. If they have issue with that, again, pointing them to the law, explaining why it is the way that it is, and if they absolutely just won't budge, worst case, it may not be the client for us.
And sometimes the question does come up, service animal versus emotional support animal, or just more generally a support animal. Really cool thing that HUD has done recently, they issued promulgated a rule. It's the assistance animal notification, and it provides more standards and guidelines. So if we have a question here with the emotional support animal, it's not a qualified service animal, and the landlord's got questions, we can refer them to that public source. It's straight from HUD. It gives you more general information and more specific applications, and it just ties it right back to the law. Is this person who has the emotional support animal, do they need that animal because their disability substantially impairs one or more major life activities? So it ties it back to the law, but it also gives you a public resource straight from HUD that you can point a landlord to.
Questions on handicap status. May an apartment charge a pet deposit for a qualified service animal? What about a waiver or reduction in a pet deposit? So I know we just covered this, but no to both, because a pet deposit is completely inapplicable, as the service animal is a pet for fair housing purposes. Another question, though, may a condominium require that a handicapped resident pay for a modification of the handrail on the back porch of his unit when the condominium is responsible for maintaining and repairing the actual handrail?
And so this question is purposefully drafted by me to be a little bit tricky, but the call of the question is to focus on the fact that the condominium association is saying, look, we'll give you this accommodation, but you've got to pay for it. And so a lot of times folks are saying, well, it's got to be prohibited. You know, you can't make the handicapped party pay for the modification of the property, and that's actually incorrect. So the statute squarely, in the language of the statute, states that if it's a reasonable modification, that the handicapped person does bear the cost.
And you just answered the question, yes? Which of the following scenarios may raise fair housing concerns? So now we're going to have a little fun with advertising. So let's just say the advertisement reads, this home is a perfect in-town bachelor pad, walking distance from all Atlanta's hot spots. So I'm going to say no to that one for two different reasons. One is we do use the phrase bachelor pad, which would fall under the familial status umbrella. And I would refrain from walking distance just because there's so many other ways we can point out that it's close to hot spots without stating anything that might infringe on handicap status.
Right, and even the mentioning of the bachelor pad, I mean, it doesn't really bring anything to the property. I mean, do we really want to limit it just to bachelors? I mean, we really want to open it up to everybody. I mean, our seller probably doesn't care if it's a family, if it's a bachelor, so just taking that out altogether is just really the best practice. In scenario number 2, we've got an owner. It's a for sale by owner, and that owner has made up his mind that he's going to disregard any offer made by a member of a protected class. In this case, we've got a certain race. And so the question is that problematic under fair housing? And the answer is probably not. And the reason is, as you can see from the hypothetical, we have excluded brokers' involvement altogether. So an individual who intends not to list it with a broker under certain circumstances could, I mean, of course, just as a general matter, discriminating is horrible, but fair housing wouldn't cover that scenario. And so if they were to turn around and try to advertise it, then they might fall under it. And there's also another exception if they own 3 or more of these properties. And the second they get a broker involved, at that point it would be a fair housing violation if we know that a seller up front intends to do that, it's just not someone we're going to work with.
Absolutely. If we're involved in it, definitely no. Okay, so let's say a homeowners association passes an amendment to its covenants that require that all vehicles must be parked in the garage at all times. John, who is paralyzed from the waist down, has difficulty exiting his handicapped accessible van because of the size of his single-car garage. He asks the HOA for a variance to be able to continue parking in the driveway, but the HOA actually refuses, citing their covenants. I don't think that they can do that. I don't think that they can deny John the permission to park in his garage.
And you're correct. And so what this one's trying to hone in on a little bit is, we talked earlier about how the actual statute, Fair Housing Act, does not define what a reasonable accommodation would be. So you got to flesh it out, just putting facts on paper here. And as we can see, it's really just someone asking to go back to what they already had in the covenants before the change, parking in my driveway. I mean, you can imagine that that's probably not a really big inconvenience for the HOA to carry out their duties under the covenants, and so likely this is going to be a reasonable accommodation and that the HOA would not be able to deny the variance at that point.
Let's say an agent, while showing a client a couple of homes within a neighborhood, points out that there are a good many religious organizations in the area. Again, I think if we can keep our advertising and our focus on the real estate instead of activities, businesses in the area that we think that the party might be interested in that are of a religious nature, we really just need to avoid that. Now let's talk a little bit, Andrew, about best practices.
Okay, so we've got a buyer that tells an agent that she feels most comfortable in an area where she will be surrounded by people of her same national origin. She asks her agent whether Suwannee has a large population from that same national origin. What is the best response that an agent can give? So the first response we have here is, fair housing laws prohibit you, buyer, from making a decision on where to buy based on those statistics. Well, as we covered earlier, that's not really technically a fair housing violation. Now, if they had asked for our help in doing that, then of course it would, but that's probably not going to be the best response here. Our second response is, I can't say off the top of my head, but I'm happy to do some research for you on that. So the agent at this point is intending to go look at some public resources to find out what, the population of that national origin is in that area. And then our last one here, fair housing prohibits me from answering that question. However, there are online resources for that information. Of those last two, Derek, which one's the best one?
I'm going to go solidly with the third one. Definitely not number two.
And the difference there is, in one case, we're volunteering. All right, we'll go do the research for you. And in the third scenario, it's saying, very upfront. And this is one of those scenarios, don't feel bad about citing the law. Say flat out, hey, fair housing prohibits me from doing that. I'm really sorry about that. However, there are public resources that you can consult to find out information that may or may not be important to you. And keeping it really general, not just saying to find out about that national origin population, you can just say public resources have all kinds of data that you can consult, and I encourage you to do so if that's something that's important to you.
As real estate agents, we love to talk, so that might be one instance where saying a little less, but being very specific would be better. And to go back to the testers, these testers are very well trained, so they know exactly what to ask, and they can ask these questions in a variety of different ways, and so they want to possibly get you to say something that you shouldn't say. So I love what you just said. Just cite the law. No, I can't provide that information, and don't feel bad about it.
Right, and as Derek pointed out, that's a really good point. I mean, we've made these really tight, easy hypotheticals in some scenarios, but these testers are trained sometimes by HUD themselves, and they know workarounds, and they're probably not going to be as obvious as we've laid it out here.
So let's talk a little bit about Section 8 vouchers. Now, I know that we don't offer property management as a firm. However, we routinely do work with tenants and landlords to find property for lease. And the question can come up, questions from prospective tenants about Section 8 vouchers. So true or false, a landlord may not deny a tenant who wishes to use a Section 8 voucher.
So that's actually false. A landlord can have a policy that they're not going to accept Section 8 vouchers. Derek, when we were talking earlier today, he made a really good point. It's really nice to have that conversation up front. You don't want it to come up and then you have to say, well, let me consult with my landlord and I'll get back to you on that one. Talking about that up front is a really good idea because not all properties are going to qualify anyways for Section 8. Right. One of the things we do want to consider is that we want to be consistent with our Section 8 policy. So if we start out and we don't have that policy and then we tighten up and we get that policy midway through, we might be opening, as a landlord, might be opening ourselves up for a fair housing violation.
So we're also going to talk a little bit about steering. So another example here today. So Jane asks her agent to show her homes in an area comprised mostly of people of her same faith. What should the agent's response be? And one more scenario, and then I'll back up here. Jane specifically asks her agent to show her homes in Dunwoody because she feels that there may be others of her same faith in that area. What should the agent's response be? So there is a big difference in both of these scenarios in the sense that in the first example here, Jane is asking us to steer her, really. She's giving us criteria that does infringe on fair housing, and she's asking us to locate property for her based on that, which we can't do. So that our response to the first one should be, fair housing law does not allow us to locate property based on that criteria. Perhaps she can do some homework on her own. There's so many great resources online, and she can tell us, she can tell the agent where she wants to go, which is really what's going on in the second example here. She's asking to see homes in Dunwoody because she's already done her homework, and she feels like that area is going to be suitable for her.
Right, and even if she voices, it's because they're people of the same faith. We're focusing on that first part, Dunwoody. So now we're going to show her places in Dunwoody. We're focusing on the area, particularly the properties in Dunwoody. We're not looking at the people. Even though she's voiced that concern, we're going to completely disregard that as though she never said it, and we're just going to stick to our real estate business of finding property. Now, 3 key takeaways from today that I want us to all keep top of mind is consistency matters. I think everything that we talked about today, be consistent with what we're going to do. It's that inconsistency, it's that possibly going out of the way for that one client that can sometimes come back to bite us. And testers do look for that, and they are known for calling. You may have one tester call, another tester call, oftentimes within the same day, who knows, just to see if there is consistency or not in the way that the parties were treated. Another important thing to take away, just focus on the property, talk about the property, not about people or activities or characteristics of people that we think might be suitable for this party. Again, like in the Dunwoody example, focusing on the part that mentions show me properties in Dunwoody rather than show me properties where I think there will be people of my same faith.
And just a plug for advertising, advertising proofs should be sent to broker at solidsource.com for broker review and approval prior to publication, basically. And we look to make sure that those ads do meet the requirements of the Georgia Real Estate Commission, and we also keep in mind fair housing. So just keep that in mind as well, that we're looking out for you when it comes to advertising, photographs, that kind of thing. I see it more in general advertisements, for example, looking to buy or sell. If we can keep those photographs and that focus on the real property, that's just by and large going to be the right path to go down, including images of people. Even though we may try to be very inclusive, we may accidentally leave certain people out, and who knows how that advertisement may come across. And we just said that, but we'll repeat it. Ensure advertising is limited to the real property and does not suggest preference.
And like we talked about, even though I'm sure in that example that we gave you with the advertisement, they meant no harm by walking distance, but in reality, it does seem to suggest a preference. So just saying close proximity is a great alternative.